case briefs, and so much more. LSData's got what you're looking for.
In a 1980 case heard by the Nebraska Supreme Court, Gehrke v. General Theater Corp., the court ruled that a lessee is responsible for checking the safety and fitness of rented property unless there is deceit or fraud by the lessor. In this case, the Gehrkes sued the General Theater Corporation of Norfolk for unpaid rent on a theater building in Nebraska. The General claimed that it did not owe rent as the Gehrkes failed to repair the roof, causing a defect in the plaster ceiling and rendering the theater unusable, effectively forcing a constructive eviction. However, the court found in favor of the Gehrkes, ruling that rent was indeed due and General had not been constructively evicted. The lower court had determined that the sagging and loss of plaster was caused by improper installation of the lath, not the Gehrkes' failure to repair the roof. As such, the court upheld the lower court's decision, stating that it was correct and followed the law.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.